We're done. At this, we're done. No, we're done.
Imagine having your freedom on the line, facing a judge who's already given you multiple chances. Now imagine you decide to argue, interrupt, and even try to shift blame in that very courtroom. That's exactly what happened in this intense probation violation hearing, and the consequences were immediate and severe. Welcome back to the channel. Today we're heading to Beaumont, Texas for a probation violation hearing that took a dramatic turn. We're looking at the case of 43-year-old Anthony Mendoza, who 6 years prior was convicted of his third DWI. He was given a chance at redemption with a 6-year probation, which came with strict conditions: an ankle tether for alcohol monitoring, an ignition interlock device, completion of a 12-step program, and working towards his GED. But Mendoza didn't just stumble. He reportedly tested positive for alcohol and cocaine, and picked up an assault charge. Now he stands before Judge Raquel West, facing the very real possibility of his probation being revoked, and that original 6-year prison sentence being imposed.
With several conditions, including that he wear an ankle tether to monitor alcohol use, install an ignition interlock device on his vehicle, complete a 12-step program, and work towards earning his GED. But Mendoza violated his probation, not only by testing positive for alcohol and cocaine, but also by picking up an assault charge. He was arrested and today appears before Judge Raquel West to hear if his probation will be revoked. Mendoza is represented by attorney Alan Parker.
Mr. Parker, you may proceed.
Here we see the defense attorney, Mr. Parker, kicking off the hearing. In a probation revocation hearing in Texas, the state typically bears the burden of proving by a preponderance of the evidence that the defendant violated one or more conditions of their probation. This is a significantly lower standard than beyond a reasonable doubt, which is required for a new criminal conviction. The defense attorney's job here is to mitigate the damage, argue against the alleged violations, or present reasons why the probation should not be revoked despite the violations. Mr. Parker immediately highlights the financial burden of Mendoza's monitoring devices and programs, attempting to present a sympathetic picture, and suggests that these costs hinder his ability to comply. This is a common defense strategy, acknowledging challenges while trying to avoid the most severe consequences.
Well, a couple things I want to address. He's ordered to have the scram and interlock. It's costing him $600 a month. He can't afford to pay for the things he needs to do, such as the 12-step program, the GED program, all those things require money. He has no other felonies, Judge. He wants to complete his probation, and I think you'd also like to address the court, Judge.
So here's the thing. This is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. And then we have aggressive behavior, ongoing alcohol use. Mr. Nichols?
The judge checks in with the prosecutor, Luke Nichols, who appears off camera.
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we can do. So obviously I agree with the probation department's recommendation for revocation.
The prosecutor, Luke Nichols, is making it clear that from the state's perspective, Mr. Mendoza has exhausted his opportunities. The key phrase here is zero tolerance. When a defendant is placed on zero tolerance probation, it means any violation, no matter how small, could lead to revocation. This isn't just about the number of violations, but the pattern of noncompliance, especially with alcohol use, which was central to his original DWI offense. In Texas, a motion to revoke probation for DWI will often cite violations of conditions outlined in the Texas Code of Criminal Procedure, Article 42A.301, and specific orders from the court. The prosecutor is essentially telling the judge that probation has failed, and continuing it would not serve justice or public safety.
Mr. Mendoza, you have been given so many opportunities on this probation. I mean, seriously, 3 times haven't revoked you, and here we are with all of these violations.
I've actually done well through the program, through with the supervised division. The only time I messed up is when they stopped supervising me and made me go do these things by myself.
Well, I mean,
this is a
how
critical
old are you?
moment where Mr. Mendoza attempts to explain his side directly to the judge. While
43
defendants
years
do have a
old.
right to address the court, this statement is a risky one. He's attempting to deflect responsibility by blaming the probation department for stopping supervision. Judges often view such statements as a lack of personal accountability, especially for a 43-year-old adult. Probation, by its very nature, expects individuals to take responsibility for their actions and actively work towards rehabilitation. Shifting blame can quickly erode any remaining goodwill or sympathy the court might have, reinforcing the prosecutor's argument that he's not taking the situation seriously.
Those tools and do for yourself, and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools.
If I can get
We're done. We're done. No, we're done.
And this is where the judge's patience reaches its breaking point. Judge West explicitly states, "We gave you the tools." This is central to the concept of probation. It's not a free pass, but a conditional opportunity for rehabilitation with the necessary resources provided. When a defendant continually fails to utilize those tools or follow conditions, it's seen as a direct affront to the court's authority and a rejection of the chance they were given. The defendant interrupting the judge further exacerbates the situation, demonstrating disrespect for the court. In Texas, judicial temperament and courtroom decorum are taken seriously, and such an interruption can swiftly lead to a loss of any leniency. The judge's immediate declaration of "we're done" signals a definitive end to the discussion and indicates her decision has been made.
After hearing the defendant's comment, the judge does not look happy.
Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. So I'm going to find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to 6 years in the institutional division of the Texas Department of Corrections.
The judge sentenced Mendoza to 6 years in prison with credit for 292 days time served.
So what was the final outcome for Anthony Mendoza? After the judge's firm decision, Anthony Mendoza's probation was officially revoked. He was sentenced to 6 years in the institutional division of the Texas Department of Criminal Justice, with credit for 292 days time served. The court found Mendoza's pleas of true to the numerous probation violation counts, meaning he admitted to the violations, to be freely and voluntarily entered. He was also provided with a certification of his right to appeal the decision. This case serves as a stark reminder. Probation is a privilege, not a right, and judges expect personal responsibility and strict adherence to court orders.